Hi, Jenny. How
Hi,
are you
Henry.
doing?
I'm doing well.
Not
How are
too
you?
bad, not too bad. Enjoying some unseasonably good weather on this side of the country. I don't know what the weather is like in Stanford, but I presume it's it's as nice as it usually is in that part of the world.
It's it's always nice
Yeah.
at Stanford, even when it
Yeah,
rains.
well, I love Northern California. I'm from Ireland originally, and so slightly cool weather and rocky coasts are all good by me.
Yes,
Anyway,
absolutely.
so I guess we wanted to start by talking about a forthcoming piece that you have in the Boston Review, which talks a lot about slavery and law in the 19th century, but which also has a lot of contemporary significance for how we think about international law. So maybe the best way to start is if you want to talk a little bit about what your article says.
Sure. Well, so I have this short piece that's just coming out right now in the Boston Review, and then a much longer version of the article that's coming out later this fall in the Yale Law Journal that's sort of more of an academic piece. And it's looking at these treaties in the 19th century for the abolition of the slave trade that created international courts for their enforcement. And they've been basically forgotten by modern international lawyers, human rights activists, but they're a very interesting historical example of the use of international law and in particular international courts for an international human rights goal. So there were these courts, they were set up by treaties of which Great Britain was the main instigator, and they banned the slave trade by countries that signed on. The main countries in the beginning were Spain, Portugal, and then later Brazil, and eventually even the United States. And they created these international courts where illegal slave trading ships could be brought in for trial. And if the ship were found to be, say, a Spanish ship that was illegally engaged in the slave trade, then the court would condemn the ship and it would be auctioned off and the slaves on board would be freed. And over the sort of lifespan of these treaties, the courts heard about 600 cases and freed 80,000 slaves off of the captured slave trading ships. Now, that was sort of a drop in the bucket in terms of the transatlantic slave trade, but certainly they heard far more cases than most modern international human rights courts, about which people have been spending a lot of time and attention. And if you look at the sort of overall arc of the abolition of the slave trade, I think the treaty regime and the role that the courts played in it had a significant role, along with a bunch of other developments in world politics and cultural sensibilities regarding slavery, that together led to over a span of a few decades, the abolition of a trade that had sort of flourished for centuries and that was still quite lucrative for the people involved in it. And so I think it's interesting both sort of looking back just as a pure historical matter to remember this, but also in terms of looking at some of the contemporary issues about the potential for human rights law to make changes in global society, for the role of international courts, whether they can be effective in changing national attitudes and practices.
Well, one of the reasons I think this is a really interesting story when we look at the world today is, in a way, the Great Britain plays the same role as the US does today in your story, which is to say that it's the powerful, it's the most powerful actor in the world. That, to use international relations theory, it's the hegemon, it's the rule setter. And so what we see here is a very interesting example of a combination of force and persuasion to try and get norms developed. And and you talk about this a little bit in the piece. The interesting question is, what kinds of lessons does this hold for the US? Because we see this debate about US power in the world, where on the one hand there is sort of a lot of people advocating strong intervention in different parts of the world, such as Iraq. On the other hand, there are people who they're both realists who believe that the US shouldn't be doing this kind of stuff, and there are people who believe that it's immoral of the US to interfere in other societies. So what kinds of lessons does this have for the US today?
I think it's a really interesting comparison. Of course, every time and place is different, and so circumstances of Britain at that time are not exactly the same as the U.S. today. So with all of those sort of caveats, it is true that Britain was the sort of hegemon, particularly with respect to power over the seas. They had the most powerful navy at that time. They had just won the Napoleonic Wars, basically, over France and its allies, and had really proved themselves to be militarily superior on the oceans. And they were also at that time very strong economically. And so it's interesting to see, at times they used their hard powers. They used their superior naval military force. They used their wealth to sort of bribe other countries into joining this treaty regime against the slave trade. But there are a couple ways in which I think Britain's actions or attitudes toward international law are different from those of the United States today, and that are significant. The U.S. today, many people view, who are interested in the U.S.'s exercise of power, view international law primarily as a threat to U.S. sovereignty. International law is something that will constrain the power of the United States and that will prevent us from doing what we want or advancing our interests. And Britain, to a large degree, saw international law as a tool that it could use to, for lack of a better word, to project its power, but also to persuade other countries of the rightness of some of its ideas. And so by using these international treaties, Britain was able actually to project its power much farther into the future than it otherwise would have been able to. So to to sort of get a little more concrete, right during the Napoleonic Wars, Britain was unilaterally seizing slave ships of other countries on the high seas and condemning them in British national vice admiralty courts. And there was sort of a loophole in the law of nations at the time that allowed for wartime seizures or searches of ships to make sure that they weren't violating neutrality or that they weren't enemy ships. Britain took advantage of that to search these ships on the high seas, and if it found them engaged in the slave trade, it would take them into its national courts and condemn them. And at the end of the Napoleonic Wars, that loophole closed because that was a wartime right of search under international law. Britain's navy was so superior at that moment that if it had really wanted to continue capturing, let's say, Portuguese and Spanish slave ships, it probably would have been able to. Spain and Portugal were at that point totally dependent on Britain, both economically and militarily, for support, and just very heavily dependent on Britain's goodwill and continued sort of aid. And so at that moment in 1815, 1816, through the late teens, Britain could have just done it on its own using its force. But instead of doing that, instead of sort of just relying on its hard powers, it instead used those powers to persuade Spain and Portugal to enter into treaty agreements that condemned the slave trade as against the interests of justice and humanity, and created these international courts to enforce that ban, which had both Spanish and Portuguese as well as British judges on it, and that allowed the Spanish and Portuguese to search and seize British ships that they suspected were engaged in the slave trade if they wanted. And what that did in terms of Britain's power was it allowed Britain to project that power decades into the future, so it was still utilizing those treaties 20, 30 years later when the power dynamics had changed. Certainly Britain was still quite powerful, but the dependence of those countries was not quite the same. Circumstances had changed over those decades. And so Britain did two things there. One, it gave legitimacy to its actions, and it subjected itself to the same rules that it was trying to enforce on these other countries. These were mutual treaties that gave them the right to search British ships as well. Now, of course, the imbalances in the naval power meant they weren't necessarily going to exercise that power to the same degree that Britain was, but it was a kind of formal legal equality that mattered to the sort of dignity of those countries and their willingness to sort of say, okay, we could be part of this treaty regime. So Britain's sort of willingness to subject itself to the legal regime gave its actions a legitimacy, and its decision to use its momentary power to try to get long-standing legal institutions put in place meant that it was able to project that power into the future. And so far from being a limit on Britain's sovereignty or an affront to the sovereignty of British ships sailing on the high seas, it was instead a way of, in the long term, advancing Britain's interests in a way that was sort of consistent with the rule of law.
So, in a certain sense, this is like what the international relations scholar John Eikenberry talks about in his book After Victory, when he talks about the ways in which after World War II the U.S. created a whole bunch of institutions, the Bretton Woods institutions and others, which were aimed at sort of reflecting American values, even after American power had declined, to make sure that whatever sort of institutional dispensation there was continued to be something that reflected America, but that in order to do this, America had to bind itself in its allies' eyes in order to say that it too was going to be subject to the same sorts of rules, same sorts of regulations as the other countries were.
Yeah, that's absolutely what the U.S. did in the aftermath of World War II, with the Bretton Woods institutions, with setting up the United Nations, with putting in place both the framework for sort of economic rule of law as well as for security and human rights. And the U.S. seems to have forgotten that lesson. So you can even just compare the U.S.'s attitude towards the International Criminal Court with its attitude originally towards the first permanent court of international justice, which was created under the League of Nations after World War I. And the U.S., of course, had a sort of ambivalent relationship with the League of Nations, to say the least, and was not immediately willing to be a party to that court. But on the other hand, far from trying to undermine the court or destroy it or weaken its power, the U.S. Sent observers, sent lawyers who could participate in the court's operations and try to shape the institution in a way that the U.S. felt would advance the U.S.'s long-term interests. And then when the Permanent Court of International Justice became the International Court of Justice under the UN Charter, the U.S. Finally began to participate in that court and did so for many years and used it as a tool in its own international policy until very recently, when under many treaties like the Vienna Convention on Consular Relations, the U.S. Withdrew from the clause allowing the resolution of disputes in the International Court of Justice, which the U.S. had in fact was a clause the U.S. had used to its own advantage during the Iran hostage crisis when it brought suit against Iran in the ICJ.
So why is the U.S. behaving like this if it's not in its long-term interests? And I think it's pretty easy to attribute this all to the Bush administration, but we've got to remember that a lot of the hostility towards the ICC came from Democrats in the Senate as well. And even while the Clinton administration was negotiating the treaty, it was trying to make it as weak and as non-binding as possible. So it seems to me to be a bipartisan issue. And why is it that, in your opinion, that if this is such an obvious thing to do, that the U.S. seems to have lost track of its own interests in this?
I think there's a huge difference between the Clinton administration's approach to the ICC and the Bush administration's approach. The Clinton administration, to be sure, was concerned about whether the court would constrain the U.S. in ways that would be not to the U.S.'s advantage. But its response to that was through engagement with the court, through very active participation in the Rome Conference, through trying to get things in the treaty that would try to prevent the court from engaging in wild goose chases or sort of abusive use of its powers, but still give the court enough independence and legitimacy that it would be respected by the world. And the Clinton administration was engaged in those negotiations, and although it felt like the U.S. wasn't ready to actually join the court yet, that it wanted to spend some time to see how things played out, that it would participate and shape the evolution of the institution, whereas the Bush administration's approach had very much been, let's destroy the institution, let's withdraw, let's do everything we can by making other countries sign these Article, the 94, 93 agreements, where they would agree not to turn any Americans over to the court and that sort of thing. Now, it's interesting if you look back at the at the slave trade courts, you actually see that this is not a new kind of tension in U.S. foreign policy. I mean, the pull between the desire to be engaged on the world stage and to advocate for human rights and things that the U.S. considers as sort of its contribution to the world is present there. So the U.S. resisted joining Britain's slave trade regime for many years. It went to the Senate in the 1820s and looked like it might be ratified at that point, but the Senate added some amendments to the treaty that were unacceptable to the British. And so there was a sort of halting efforts by the U.S. to suppress the slave trade, because the U.S. banned it in 1808, just the year after Britain had, the first year allowed by the U.S. Constitution. And the U.S. would periodically send ships off the coast of Africa that would patrol along with British ships to try to catch illegal use of the American flag in the slave trade. But it was a very ambivalent relationship, and it wasn't until the middle of the Civil War in the 1860s when President Lincoln's administration finally agreed to sign the slave trade treaty with Britain that created an Anglo-American International Court for the Suppression of the Trade. And even then, the U.S. did sort of a weird thing where they asked the British to pretend that the Americans had initiated the negotiations in the 1860s, even though, in fact, the British had made the first overtures to say, hey, do you want to finally join on to this regime? But the U.S.'s participation at that point, after the U.S. had seen the operation of the courts for a number of years, and perhaps at that point felt a little more comfortable with joining them, also wanted to curry favor with the British, to be sure. But that was an essential thing that finally led to the suppression of the slave trade to Cuba. But I guess the broader lesson from that is that the U.S.'s ambivalent relationship towards international law is not new. It seems to have been with this country since its founding, and sort of a push and pull between viewing international cooperation is something we want to engage in and something that we want to isolate ourselves from.
Well, moving from the more specific issues of international law to the general issues of human rights in the international realm, so your piece seems to me to be a little bit awkward for both sides in the debates over these things, in that on the one hand you're arguing that this kind of stuff these interventions really work best when they're in accordance with international law. The Brits seem to have been very, very careful, as you say, about only doing this, only sort of boarding ships to search during wartime and whatever. But on the other hand, you also seem to be suggesting, unless I'm misunderstanding you, that it sometimes is necessary to use military might in order to pursue human rights, even when other states might not necessarily want them to do so. Is that more or less what you're saying, or am I misinterpreting you here?
Yeah, I think so. I mean, I'm a bit of a human rights hawk, and I think for me that personally stems from my experience working at the International Criminal Tribunal for the former Yugoslavia. And while I was there, I was an assistant to the American judge, Judge Wald, and she worked on the Krsta's trial, which was the trial from Srebrenica, from probably the worst massacre of the Bosnian Civil War, where in the span of a few days, something like 7,000 men and boys from the town of Srebrenica were rounded up and executed by the Bosnian Serb forces that took over that UN-safe enclave. And so Srebrenica had been declared a safe area by the UN. It was a place where civilians were supposed to gather to be protected from the ongoing civil war, and the Bosnian Serb forces got it in their sights as an area of territory they wanted to capture, that they believed it should be part of the Serb territory. And sitting through that trial, really, for me, and this is just a sort of personal experience, really showed the value that a small military intervention could have. That if the UN peacekeepers who were there were basically begging for close air support from NATO, and they didn't get it. And you see in looking at the intercepted communications between the Serb forces that they really didn't begin thinking that they were actually going to take over the Srebrenica enclave. They expected to constrict its territory, to push the boundary in a little bit further, but they expected that at some point they would get some pushback, that the NATO planes would sort of appear and give a little close air support, start bombing their positions, and then they would halt their advance. And when that didn't happen, they were emboldened to go in and go through and engage in this ethnic cleansing, to massacre the civilians who were in the enclave and to take it over. And for me, that was a powerful experience to sit through that trial and to hear those intercepts from the Serb forces and then to see the very deadly human consequences. And, so there was, of course, a lot of debate as well over the NATO bombing in Kosovo, whether that was authorized, whether it was illegal under international law, whether it was nevertheless legitimate, whether human rights violations were committed by NATO forces in bombing Belgrade. And two things from that. First, for people who were familiar with what had happened at Srebrenica, it was hard not to look at the Kosovo bombing and think that it was probably a good thing, that it had probably saved lives. And it also goes back to the question of U.S. participation in international institutions. So human rights groups had asked the ICTY to investigate the NATO bombing campaign for potential prosecution of NATO for its use of munitions for the civilians that were accidentally killed during the bombing. And the prosecutor investigated and decided that not to bring any charges against NATO or anyone in NATO. And one of the reasons, and I think that was the right decision, because while there were civilian targets that were hit, there was just a vast difference in terms of the scope and intent of the NATO bombing campaign as opposed to the deliberate targeting and killing of civilians that occurred in so many circumstances in the wars in the former Yugoslavia. One of the reasons that the correct result that was reached there, I think, was the fact that the U.S. had many people who were participating in the ICTY, who were in the prosecutor's office, who were not there out to get the U.S., but were there and had the ability to prevent a kind of politically motivated prosecution against the U.S. and its NATO allies. There were plenty of people from other countries there as well to make sure that it wasn't just the U.S. sort of, cooking the books so that it wouldn't get prosecuted. But the participation of the U.S. protected our interests, and its participation in an international institution gave the whole process the legitimacy that it would lack if it were totally under the control of the U.S.
Okay, well, this sort of seems pretty sensible to me. The argument that if you don't have people within the system, that inevitably you're probably going to get more direct confrontation and perhaps some spurious prosecutions happening. But I'm somebody who thought that that NATO's intervention in the former Yugoslavia was was far weaker than it should have been and long overdue. So I completely agree with you on everything that you say there. So I also have some very real problems with the way that, for example, the U.S. used various humanitarian justifications in order to justify going into Iraq. And so, it's an interesting question. So given that international law itself doesn't seem to provide any very good answers on when you do this, when you don't. Certainly, as you say, there was a lot of doubt about whether or not some of the stuff that happened in the former Yugoslavia was legal given the lack of a Security Council mandate. How do we figure out a world in which people go in, so the US is prepared to go in and to act when it's genuinely necessary in order to prevent humanitarian catastrophes, while not actually at the same time creating the kind of humanitarian catastrophe that it arguably has done in Iraq?
That's the $1,000,000 question. What do you think?
I wish I had an answer. I don't know.
I think they're important. As an international lawyer, I think there are important legal distinctions between the Kosovo intervention and Iraq in terms of legality under international law. Now, there was not Security Council authorization for Kosovo, and many people think that means that it was illegal. On the other hand, I think there were more credible claims for authorization there, partly because it was an action not just of the U.S. and the coalition of the willing or the billing or whoever the U.S. could persuade, but it was part of NATO, which was an established regional organization that wasn't created just for the purpose of engaging in that war, but had a kind of pre-existing legitimacy and legal framework. In addition, there were the pre-existing Security Council resolutions and the Security Council's refusal to enact any measure condemning the Kosovo bombing, I think, if you just look at the text of the resolutions that were at issue in Kosovo, there's a greater argument for Security Council legitimacy there than there was in terms of Iraq, and the legal arguments that were made about, for example, whether the invasion of Iraq could plausibly be claimed to be authorized by some much earlier Security Council resolutions. Just in terms of the sort of textual, nitty-gritty legal arguments, I think the argument for Kosovo was better than the argument in Iraq. And so I don't think our existing international legal framework in terms of the Security Council is perfect, but I think it has it does provide some legal guidance more than, for example, the Bush administration would acknowledge.
Okay, well, so I'm prepared to accept that, I think, on pragmatic grounds, so that the Security Council and sort of clearance is a sort of means that something is going to be a lot more likely to be successful. But I do think that the people who claim that the Security Council, when you're talking about an institution which has Russia and China effectively having veto power, it's hard to argue that this is going to be something that is necessarily going to support the humanitarian view of things, given that those states very clearly have important interests and have important, very serious problems of their own in terms of their internal human rights practices.
Yeah, I mean, I think that's the problem with the Security Council and with other UN human rights institutions, like the new Human Rights Council is the same as the old Human Rights Commission in terms of having violator states kind of exercising veto power over anything that might be done. And so I think that's, the difficulty of coming up with a legitimate framework for humanitarian intervention. And I think regional organizations actually do have more of a role to play than perhaps people commonly think. Organizations like NATO or the Organization of American States or the African Union can have a role there that could be significant. But I think that the problem of controlling and legitimizing humanitarian intervention is one argument for the use of international courts like the ICC that are more independent of the sort of world power politics. There's still a role for the use of force to back up those institutions. And so I think one of the interesting things, if you look at the experience of the ICTY, is the role of NATO in helping that court execute on its arrest warrants. A lot of people say, well, the problem with the ICC or the problem with international criminal courts is they don't have police, they can't go out and arrest people. And one of the things that you see with the ICTY is that, once they sort of managed to persuade NATO, which has peacekeepers in the former Yugoslavia, to go out and start arresting these war criminals, that at that point, the court begins to actually hear cases. And so it's not just the use of force in terms of, we're going to invade a country and put a stop to an ethnic cleansing, but the use of force in more of a police power way of catching criminals. And I guess also on the international intervention point, you've also seen some pretty successful interventions in Africa by the British in Sierra Leone, by the French in Cote d'Ivoire, where there is, even with the sort of barriers to things being decided in the Security Council on particular localized interventions, whether they're also in Haiti, the intervention by an international force. The fact that it doesn't work in all circumstances doesn't mean that there haven't been many cases where there have been successful interventions.
But also, and here I'm playing devil's advocate a little bit, some of these interventions, while they may have been successful in their end result, would have been rather hard to justify ex ante given the kinds of norms that we usually think. Think about, for example, Sierra Leone. We saw a lot of use of mercenaries of, wasn't it, Sandline International as a basic proxy for the British in the initial stage. And Cote d'Ivoire, there's obviously the whole legacy of French colonial politics, of the French government playing one side against the other, and and yes, while these have been successful in the sense of stopping of sort of what could have been absolutely appalling human rights situations, it seems to me that it's hard to come up with principles by which you could say this justification is okay and this justification is not, except in a very, very ad hoc way, which doesn't seem to me to be easy to reconcile with the kinds of things that you international lawyers favour in this.
I don't know that you necessarily that it wouldn't be possible to come up with more principled guidelines in terms of, for example, even sort of, and of course there are going to be empirical questions of how you correctly determine this, but a quantitative aspect of gravity to a situation in terms of the number of individuals who are likely to be killed, and again, yes, you'll have disputes about that, but to set a level of gravity, if it's a situation that poses a threat of loss of life on this scale, that it might be inappropriate for an intervention. I think that having multilateral organizations like regional organizations involved in the decision making can be useful. I think you could constrain you can impose tight constraints in terms of, there's a distinction in the law of war between jus ad bellum and jus in bello. That is the decision to use force and then constraints on your use of force. And one of the things that I think is often problematic in humanitarian interventions is, are the people who are intervening obeying the jus in bello? Are they obeying international humanitarian law in terms of their participation, in terms of protecting civilian targets, in terms of not torturing prisoners of war, or things like that? And one of the things that I think is important is to the extent to which countries that might be engaged in a humanitarian intervention should be held to a very high standard in terms of their compliance with international humanitarian law, the law of participation in armed conflict. I think that mitigates some of the harms of humanitarian intervention as well.
Okay, moving on a little bit, what kinds of lessons do we have for tough situations such as what's happened in Burma, which seems to me to be a very hard case, in that on the one hand there doesn't seem to be all that much that external leverage can actually do here, which is to say that there already is a fair amount of sanctions against the regime. It doesn't seem to have changed what they want to do very significantly. But on the other hand, the regime seems to have no compunctions whatsoever about killing perhaps very, very substantial numbers of its own citizens in order to protect itself, and in order to what kinds of options do we have, and what kinds of possibilities might international law offer here that, if any, that would sort of make it a little easier to get things done in these situations where direct military intervention probably isn't on the cards?
It's a really difficult question. I mean, there are sanctions, and sanctions are something that are in part controlled and constrained by international law. And there's a lot of debate about the effectiveness of sanctions and the extent to which some types of sanctions can harm populations in the countries that are being economically excluded. And again, there's I think the Burma situation highlights the importance of regional activity, because the big problem with Burma seems to be that its neighbors, that the people it's trading with in that region, not only China but also Thailand, which is getting a huge amount of natural gas from Burma, are not willing to do as much as countries, say, like the U.S., which has had a more extensive sanctions regime. What do you think should be the U.S. response to the recent events in Burma? I'm interested to hear what your thoughts are.
As I say, I think it's a very, very tough case. I would guess that sort of where the interesting politics lie is probably not within the U.S., but as you suggest, in the neighbours, and in ASEAN, the regional organisation, where there seems to be a little bit of a push to try and, at the very least, embarrass Burma a little bit, but not very much more than that. So I think that the contrast with the former Yugoslavia is instructive, because very clearly a lot of what's been happening in the former Yugoslavia is that various states have had some incentive to play nice because they've wanted to join the European Union, and there's been a lot of sort of positive economic incentives that go along with that, as well as the European Union having basically said, unless you obey certain minimum human rights norms, we don't want to do business with you, and you have zero chance whatsoever of getting into the club. Whereas also the ASEAN club, it isn't as valuable in the first place because it isn't as highly developed, and secondly, the current members of the club, for various reasons of their own, Thailand included, have their own difficulties with with too strong notice being paid to their internal democratic practices, and so I think that that means that that there's a lot less that can be leveraged there than could be, for example, could have been and was leveraged, for example, with regard to various states in former Yugoslavia, Croatia, and finally Serbia after the Milosevic regime collapsed.
Yeah, I mean, in some ways, it's going to be very interesting to see what happens, because, and I don't think anyone has a good way of predicting this. I think where countries just internally reach a tipping point, and when they do, it's up to the international community to do as much as they can to support the internal dynamics moving towards democracy. And it's be interesting to see whether Burma reaches this point. I mean, it's interesting if you look back to the South Africa example. People debated, did the sanctions against South Africa do anything in terms of bringing an end to apartheid? And a lot of debate about that, but what also finally seemed to happen was a sort of internal process, and to the extent the international community could support the forces that were at work in the country when they realized, okay, now this is kind of the critical moment. I think that's really significant, and I don't know a lot about the internal dynamics of society in Burma or Myanmar, but apparently from what I've read, the Buddhist monks do play an incredibly important role in the society. And to what extent has the regime there gone too far? To what extent will there be a change in sort of attitudes? I think it's really hard to say at this point, but I think that even those neighbors in Asia who may not want to have a critical eye turned to their own practices, if they see Burma reaching a tipping point, I think they're likely to, throw their weight on the side of the democracy activists, but they're also likely to kind of wait and kind of hold their cards until they see, has this reached a tipping point or not.
Well, I think there are a couple of things there. First of all, the extent to which economic interests may prevail over political druthers here. There's a lot of economic activity, as you mentioned, with regard to Thailand and natural gas, and also a lot of stuff with regard to illegal logging. And this kind of, the latter kind of relationship is likely to be much harder to pull off in a situation where the Burmese government is more, is more accountable and is more subject to the standard norms of the international community, which would suggest that there are going to be some significant economic interests in Thailand who actually have a very strong interest in things remaining as they are. But what's even more interesting here is the problem that is presented by the US. So if the US wants to aid in these sort of more quiet forms of development within the countries in question, it may find it much more difficult to do. I think Iran is a great example here. The Iranian dissidents don't want to have very much directly to do with the US, because the US has basically said that it has devoted a sort of a substantial sum of money, more or less, to the purpose of toppling the Iranian regime. And when you have the US, on the one hand, threatening to go to war against Iran, sort of sotto voce, and on the other hand, sort of seeking to help domestic groups, well, then those domestic groups clearly suffer the risk of losing a lot of legitimacy. And as Matt Iglesias, a blogger, pointed out today, the US doesn't necessarily have all that much incentive to try to necessarily help help these activists very often, so much as being perceived to help these activists, and sometimes can have a downright counterproductive role.
Yeah, I think the other piece of the picture that that's important is non-state actors and multinational corporations that are involved in business. In Burma, there's sort of the interesting case of Doe versus Unocal, which was brought in U.S. courts against Unocal for its alleged participation in human rights violations and building pipelines in Burma. And that case was brought in U.S. courts under the Alien Tort Claims Act, which has been a very controversial statute in terms of allowing U.S. courts to be involved in these civil lawsuits against human rights violations in foreign countries. That case settled out of court. No one knows exactly how much the settlement was for, but it was reportedly quite a large settlement. And so, to what extent, if you have private actors, multinational corporations who are involved in a lot of things, in development, in the use of human rights abuses that are done in connection with their business activities, in the illegal arms trade, in other types of trades that support human rights violations. How do we deal with these non-state actors who are quite influential and who are subject to different levers of influence than states, because they're all about money. I mean, states have a variety of interests in terms of their policies, their dignity, their public relations with their populace. Corporations are very interested in the bottom line. What kind of leverage can the international community get out of regulation of business?
Well, and as you say, so it's pretty interesting, the Alien Torts Act, which is, I guess, a story that non-international relations and non-international lawyer folks don't know a lot about, so how this seemingly obscure instrument from the late 18th century, wasn't it? Was the early 19th century was developed into a powerful weapon that has been used by human rights groups to get at groups like Unocal in U.S. courts. It's a very interesting story, and perhaps illustrates not only the power of how you can do stuff through non-state actors, but how domestic courts as well as international tribunals can play an important role in this.
Yeah, absolutely, and it's it's a statute that's been used a lot in the past 2 decades after sort of lying dormant for 160 or 70 years, and a lot of people thought that the U.S. Supreme Court was going to kill it as a way of bringing these lawsuits in U.S. courts back in 2004, but the Supreme Court left the door open to continued use of the statute, and then there are periodic efforts in Congress to change the rules, but for now it's something that's still there, and it's the exercise of universal jurisdiction is something we saw a lot of national courts playing with, especially in the late 1990s, the Pinochet case, other cases that were brought, Belgium's universal jurisdiction statute, which has since been changed, but there was a lot of use of national courts, and actually, going way back to the slavery courts thing, you saw that as well there, where at times when the international courts wouldn't work, Britain would use its domestic courts enforcing international law to bring slave trading ships to justice as well.
Well, talking about domestic courts, a lot has been happening with the Supreme Court over the last couple of years, and some interesting speculations as to how the politics of the Supreme Court is changing, given the appointment of two more conservative justices, whether or not the balance has been shifting. Jeffrey Toobin has a new book. Is this something I know that there's stuff that you argue, which sort of may preclude you from talking too politically about this, but is this stuff that you follow, and what's your opinion on what's been happening and what's likely to happen in the future?
Yeah, I mean, we're all, lawyers, we're all close Supreme Court watchers, and me particularly, because I do litigate cases in the court, and none of us want to offend any of the justices by saying anything too political. But at the same time, I think everyone who practices in the Supreme Court has recognized that Justice Kennedy is now the swing vote on the court since Justice O'Connor retired, and since Chief Justice Roberts replaced former Chief Justice Rehnquist. And last term, I think a lot of people were surprised, perhaps, to see Justice Kennedy siding with the court's more conservative wing in many of the cases that were decided. But a lot of court watchers think that in this coming term, Justice Kennedy will be the swing justice, and he'll swing with the court's more progressive wing to side with them in several of the cases that may come up, including the Guantanamo case that's going to be heard this term. There are a bunch of other cases involving the death penalty, voting rights, things like that, where you may see Justice Kennedy staking out a position that is on the more liberal side of the court this term. And so I think it's too early to say, what the Roberts Court is going to be like in the long term. But I do think that Justice Kennedy will be a swing vote for sure.
It's pretty interesting. And so you say that you and other people follow the politics of this closely. Is this through, and here I'm asking purely from personal interest, is this through gossip, through close reading of the opinions, through, how do you guys seek to, how do legal academics seek to gauge what's happening? An anthropological question.
People read the opinions very closely. People watch. Some people will watch or listen to the oral arguments to see what kinds of questions the justices are asking. They look not only at the opinions, what's written, but which justice is assigned to write the opinion. The senior justice in the majority assigns the opinions, and there's often very strategic considerations. If you're, into who gets assigned the opinion. Do you assign it to someone who's going to write a very extreme opinion to maybe advance your view of the law, or do you assign it to someone in the middle who's going to write a very narrow opinion, but that's going to be better at keeping a majority, and it's going to be more conservative in the kind of old-fashioned, not the right-wing conservative sense, but in the conservative, like, not changing much sense. And so people look at the assignment of opinions and things like that as well. And, of course, there are blogs that cover all of this that, people can read if they're interested in in following it.
I guess I'm sort of, as a political scientist, two of my colleagues here in George Washington wrote a spoof article a couple of years ago. They discovered that apparently the Supreme Court justices keep a betting pool as to who's going to win in the particular election. So their suggestion was that Gore versus Bush was decided not with regard to the merits, but in order to ensure that a majority of the Supreme Court justices actually won rather than lost the sort of $5 or $10
in the betting pool. Well, under Chief Justice Rehnquist was very into football and basketball pools, so there must be a grain of truth in that story, because there was some gambling over sports in the court under Rehnquist, for sure.
I had a chance to ask Ginsburg about it a year or two ago, and she not only confirmed that this continued to happen, but apparently Clarence Thomas is the wizard who scooped the pool the last time round. So.
Not surprising.
Go figure. So one final, much more goofy topic. I sent. There was an interesting story, I think it was in the Post or the Times, and also in the International Herald Tribune recently, which was about the practice of lawyers and law firms seeking to recruit through YouTube. Is that something? Yeah.
Yeah. What are they thinking? I mean, a law firm is not cool. Like, no matter what they try to do, they're just going to end up looking kind of goofy making YouTube videos. You're lucky you're a political scientist. You don't know what law firm lawyers do all day, but I worked at a law firm, and I loved my law firm. They were great. I won't even say their name here to avoid harming them. But this is what associates at law firms do. They sit quietly at their computer all day looking at cases on the screen and reading documents. And there's just nothing that's at all telegenic about that. And so, they're making videos of these people out, playing Frisbee. Well, no law firm associate has time to play Frisbee. You're billing by the hour, and you bill a couple, $300 or $400 an hour. They don't want you playing Frisbee. They're not going to let you do that other than for the video. So I don't know what they're thinking.
Yeah, I don't know either. Well, my wife will say, I may not be a lawyer myself, but I'm married to one, and so
Oh.
So I know all about the billing and all about the long hours, and so while it's the kind of stuff that may be fun and exciting to talk about with your colleagues, it isn't exactly the kind of thing that's going to translate over into YouTube as being the hottest and hippest and most happening
Here's what I'd like to see on the video. I'd like to see the associates marking down their time in 6-minute increments so they can bill the client, and to see that little tally sheet as the associate notes, 6 minutes spent reading cases on Westlaw for such and such client. I think that would be a sort of realistic thing to put on YouTube to give a sense of what the life of a law firm associate is really like. I guess they could also have the glamorous takeout food that you get, which is the sort of the perk of law firm life. You get to order sushi and things like that to eat while you sit at your desk doing, billing your clients for every 6 minutes of sushi that you eat.
Yeah, so basically what we're calling for here is more truth in YouTube advertising.
Someone should bring a lawsuit. That is a great case for, I think that maybe some law students should bring a class action lawsuit for false advertising against the law firms. Be a fascinating test case of their First Amendment rights.
It would certainly gain them, I'm sure, a lot of extremely favorable attention from their future employers.
Absolutely. Just the way to get hired is to sue the prospective employer.
Get yourself marked out. Well,
now, the other question is, should we be making YouTube videos to promote our lifestyle of sitting quietly at our desks, reading and writing?
Well, I don't know. Maybe this is about as close as we're going to get. We're not exactly YouTubing, but at least we're videoing. We're pretending, at least in my case, I'm pretending to be a more exciting, opinionated person than in fact I am.
Me too.
So maybe this is the wave of the future. Certainly, if there's one thing that academics love to do, it's to opinionate. I'm sort of used to being hypnotized by the sound of your own voice. So maybe this is the wave of the future for us.
I think so. Well, it's been a pleasure talking with you.
It's been great talking to you as well, Jenny. So hope to talk to you again soon.
Yeah,
okay.
Likewise.
Bye.
Bye.